Buenas tardes a todos y a todas. Yo soy Roberto Saba, soy profesor de Derecho Constitucional de la facultad, de esta facultad, y decano de la facultad. Y en ese rol institucional le quiero dar la bienvenida a todos ustedes y muy especialmente a nuestro invitado especial, el profesor Robert Burt, y a mi querido amigo Martín Bomer, ex decano de esta facultad y profesor de esta facultad. Una pequeña introducción para quienes no sean asiduos visitantes a esta facultad. La Facultad de Derecho de la Universidad de Palermo tiene una larguísima amistad con la Facultad de Derecho de la Universidad de Yale. Yo diría que desde sus comienzos esta facultad se inspiró en gran parte en algunos de los valores y los principios que nutren la educación jurídica en la Facultad de Derecho de la Universidad de Yale. Muchos de nosotros tuvimos la enorme suerte de estudiar allí, instigados por un profesor que ya no está aquí, que es el profesor Carlos Nino. Y en esa facultad hubieron dos profesores, el profesor Owen Fish y el profesor Robert Burt, que incluso con más fuerza, luego de la muerte de Carlos Nino, se autoconstituyeron y los constituimos en algo así como nuestros padrinos intelectuales, nuestros padres académicos, nuestros guías en muchos de nuestros proyectos en esta facultad y en nuestras vidas y profesiones. Y es para nosotros una alegría enorme tener al profesor Burt en esta casa, luego de más de 20 años de relación que tenemos. La idea básicamente es presentarles un trabajo del profesor Burt que ya viene presentando en otros lugares, lo ha presentado recientemente en Italia y está camino a presentarlo también en Santiago de Chile la semana que viene. Y es un trabajo donde creo, para los que conocen algo de la obra de Robert, es algo así como un lugar donde se encuentran muchas de las tradiciones de investigación del profesor Robert Burt. Ustedes allí van a encontrar o encontraron vestigios de su trabajo en derecho de familia, trabajo en derecho constitucional, su trabajo en el tema de igualdad, su trabajo sobre psicoanálisis y derecho. Es un trabajo, yo creo, de alguien que ha recorrido todos estos caminos durante muchos años y, como nos decía hoy en el almuerzo, hoy tiene la libertad de ponerlos todos juntos en ese lugar. Bueno, también quiero agradecerle mucho a Martín Bomer, que lo invitamos especialmente para que modere y haga algunos comentarios en esta mesa. Como decía, el profesor Bomer fue, bueno, desde el principio de esta facultad hemos trabajado juntos en ella y luego fue decano de esta facultad por varios años y hoy es profesor tanto aquí como en la Universidad de San Andrés, en la Universidad de Buenos Aires y en un programa que tiene la Universidad de Nueva York en la Ciudad de Buenos Aires en estos días. Bueno, nada, quiero agradecerle mucho a los dos y no robar más tiempo. Quizá, no sé si Martín quiere decir algo ahora, lo dejamos para el final, entonces directamente pasar a Robert si quieres empezar. Gracias.
Thank you, Roberta, for that very generous invitation. Thank you all for coming today. I want to start with an apology and an explanation. My Spanish is terrible. I mean, it's so terrible, I won't even try. One of the reasons that it's terrible is that all of my good friends here in Argentina and elsewhere in Latin America speak beautiful English. So years ago, when I first got involved with you all and with Latin America, I took Spanish lessons and I tried to work on it, but I never could get an opportunity to practice because it seemed so stupid. You know, I would come down here with my halting kind of taxi driver English, and everyone around me spoke beautiful Spanish, excuse me, and everyone around me spoke beautiful English, And so it just became pointless for me. So I'm still incompetent in Spanish. I may still be incompetent in other matters, but I know that I'm incompetent in Spanish. So thank you for coming, but there is simultaneous translation that's going on for those of you who want it, and there are earphones, and I will be using the earphones occasionally when we have some questions. The other thing that I want to say is, honestly, I've forgotten how many years it's been since I was involved in Latin American affairs. When Carlos Nino was involved in drafting a new constitution for Argentina, I came to Argentina for the first time. There were still powerful residues of the rule of the junta. Carlos, I met him then for the first time, was an inspiring figure. And when he died at a very young age, Owen and I, Owen who had also been coming down here in connection with the drafting of the new constitution, resolved that somehow we should help to facilitate his vision. Part of Carlos' vision was that there would be a center for research that was outside ordinary universities, because he felt that he couldn't see a home in any ordinary university. And that was hard to establish, and when he died, that died with him. But I'm very happy to say that the University of Palermo has been the home for the kind of law school that is practicably attainable, but has the vision behind it that started with Carlos and that Owen and I tried to present and move forward. And we are so proud, I guess I'm old enough that I'm entitled to be proud, of Martine and Roberto both, who are the successive deans of this place, and many of the faculty of this place, for the way that they have carried out the vision that Carlos originally had and that we worked on. So thank you for speaking to all of that, Roberto. So today I'm going to present to you a summary. Let me just make sure I'm close enough to the microphone. A summary of a book-length work that I'm pulling together now, which, as Roberto said, pulls on many of my interests as a law teacher since 1968. That's a long time. I want to warn you of this. I already warned you of my poor Spanish, but I do want to alert you to this. My perspective on the law, and particularly the United States Constitution and the role of the Supreme Court, is very much a minority view. Indeed, it may be so much of a minority view to be a view of one person alone. So don't think that what I'm telling you is agreed ground in the United States. But I wouldn't be telling you if I didn't think it was right. But this is the warning that I want to give you, that I am not the mainstream opinion in the United States. So what I want to do first of all is to sketch very quickly the social history of the United States before trying to put courts and the Constitution into that picture. Very broadly speaking, the history of the United States has been one of prolonged stability. And by that stability, I mean...
Bueno, buenas tardes a todos y a todas. Yo soy Roberto Saba, soy profesor de Derecho Constitucional de la Facultad, de esta facultad, y decano de la facultad. Y en ese rol institucional le quiero dar la bienvenida a todos ustedes. Y muy especialmente a nuestro invitado especial, el profesor Robert Burt, y a mi querido amigo Martín Bomer, ex decano de esta facultad y profesor de esta facultad. Una pequeña introducción para quienes no sean asiduos visitantes a esta facultad. La Facultad de Derecho de la Universidad de Palermo tiene una larguísima amistad con la Facultad de Derecho de la Universidad de Yale. Yo diría que desde sus comienzos esta facultad se inspiró en gran parte en algunos de los valores y los principios que nutren la educación jurídica en la Facultad de Derecho de la Universidad de Yale. Muchos de nosotros tuvimos la enorme suerte de estudiar allí, instigados por un profesor que ya no está aquí, que es el profesor Carlos Nino. Y en esa facultad hubieron dos profesores, el profesor Owen Fish y el profesor Robert Burt, que incluso con más fuerza, luego de la muerte de Carlos Nino, se autoconstituyeron y los constituimos en algo así como nuestros padrinos intelectuales, nuestros padres académicos, nuestros guías en muchos de nuestros proyectos en esta facultad y en nuestras vidas y profesiones. Y es para nosotros una alegría enorme tener al profesor Burt en esta casa, luego de más de 20 años de relación que tenemos. La idea básicamente es presentarles un trabajo del profesor Burt que ya viene presentando en otros lugares, lo ha presentado recientemente en Italia y está camino a presentarlo también en Santiago de Chile la semana que viene. Y es un trabajo donde creo, para los que conocen algo de la obra de Robert, es algo así como un lugar donde se encuentran muchas de las tradiciones de investigación del profesor Robert Burt. Ustedes allí van a encontrar o encontraron vestigios de su trabajo en derecho de familia, trabajo en derecho constitucional, su trabajo en el tema de igualdad, su trabajo sobre psicoanálisis y derecho. Es un trabajo, yo creo, de alguien que ha recorrido todos estos caminos durante muchos años y, como nos decía hoy en el almuerzo, hoy tiene la libertad de ponerlos todos juntos en ese lugar. Bueno, también quiero agradecerle mucho a Martin Bomer, que lo invitamos especialmente para que modere y haga algunos comentarios en esta mesa. Como decía, el profesor Bomer fue, bueno, desde el principio de esta facultad hemos trabajado juntos en ella y luego fue decano de esta facultad por varios años y hoy es profesor tanto aquí como en la Universidad de San Andrés, en la Universidad de Buenos Aires y en un programa que tiene la Universidad de Nueva York en la Ciudad de Buenos Aires en estos días. Bueno, nada, quiero agradecerle mucho a los dos y no robar más tiempo. Quizá, no sé si Martín quiere decir algo ahora, lo dejamos para el final, entonces directamente pasar a Robert si quieres empezar. Gracias.
Thank you, Roberta, for that very generous invitation. Thank you all for coming today. I want to start with an apology and an explanation. My Spanish is terrible. I mean, it's so terrible, I won't even try. One of the reasons that it's terrible is that all of my good friends here in Argentina and elsewhere in Latin America speak beautiful English. So years ago, when I first got involved with you all and with Latin America, I took Spanish lessons and I tried to work on it, but I never could get an opportunity to practice because it seemed so stupid. You know, I would come down here with my halting kind of taxi driver English, and everyone around me spoke beautiful Spanish, excuse me, and everyone around me spoke beautiful English, and so it just became pointless for me. So I'm still incompetent in Spanish. I may still be incompetent in other matters, but I know that I'm incompetent in Spanish. So thank you for coming, but there is simultaneous translation that's going on for those of you who want it, and there are earphones, and I will be using the earphones occasionally when we have some questions. The other thing that I want to say is, honestly, I've forgotten how many years it's been since I was involved in Latin American affairs. When Carlos Nino was involved in drafting a new constitution for Argentina, I came to Argentina for the first time. There were still powerful residues of the rule of the junta. Carlos, I met him then for the first time, was an inspiring figure. And when he died at a very young age, Owen and I, Owen who had also been coming down here in connection with the drafting of the new constitution, resolved that somehow we should help to facilitate his vision. Part of Carlo's vision was that there would be a center for research that was outside ordinary universities, because he felt that he couldn't see a home in any ordinary university. And that was hard to establish, and when he died, that died with him. But I'm very happy to say that the University of Palermo has been the home for the kind of law school that is practicably attainable, but has the vision behind it that started with Carlos and that Owen and I tried to present and move forward. And we are so proud, I guess I'm old enough that I'm entitled to be proud, of Martine and Roberto both, who are the successive deans of this place, and many of the faculty of this place, for the way that they have carried out the vision that Carlos originally had and that we worked on. So thank you for speaking to all of that, Roberto. So today I'm going to present to you a summary. Let me just make sure I'm close enough to the microphone. A summary of a book-length work that I'm pulling together now, which, as Roberto said, pulls on many of my interests as a law teacher since 1968. That's a long time. I want to warn you of this. I already warned you of my poor Spanish, but I do want to alert you to this. My perspective on the law, and particularly the United States Constitution and the role of the Supreme Court, is very much a minority view. Indeed, it may be so much of a minority view to be a view of one person alone. So don't think that what I'm telling you is agreed ground in the United States. But I wouldn't be telling you if I didn't think it was right. But this is the warning that I want to give you, that I am not the mainstream opinion in the United States. So what I want to do first of all is to sketch very quickly the social history of the United States before trying to put courts and the Constitution into that picture. Very broadly speaking, the history of the United States has been one of prolonged stability. And by that stability, I mean a regime of order. The order, really dating from before the colonial times, before the Revolutionary War, has been the single longest characteristic of the United States. That order has always been based on the subjugation of the weak by the strong. The sense of freedom, of liberty, of high intellectual and principle, which has been part of our history, has always been based on this contradiction, and most notably on the contradiction with black people. From slavery to then the aftermath of the Civil War and the reinstitution of slavery, the very idea of freedom in the United States has, during these long periods of order, depended on the existence of people who were demonstrably unfree, basically as a kind of comparison. You know, in colonial times, in post-Civil War times, white people knew they were free because they could compare themselves to black people who were not free. So that, overall, and with a very broad brush, is most of the history of the United States, but it's not all of the history. There have been episodes in which the social order has been dramatically disrupted. There are three that I identify in the history of my country. And I also should tell you, what I'm speaking of now is the dominant view at the time. There were always dissenters. During periods of order, there were people who were speaking about the oppression and speaking for true liberty. But I'm speaking of the dominant mood, attitude of the time. And the dominant mood, as I say, was one of order and stability. But there were three episodes in our social history that, again, according to the dominant view, disrupted that order dramatically, and in a way that seemed to rip to shreds the very stable basis of the governance and the social relations. The first such eruption was the Revolutionary War. Now, we look back on it, and it seems like a tame affair. People running around the woods, and shooting up into the air and killing a few people. But it was not a simple matter for the colonists. In fact, it was incredibly dramatic. By breaking the relationship with Great Britain, we threw away the central token of our stability and order. And the premise was that suddenly the American white colonists saw themselves as the slaves of Great Britain. Now, I'll mention in a moment the contradiction. The same people who held black slaves were talking about themselves as slaves. And as I say, there's a deep contradiction there, and it wasn't lost on the colonists. And in a moment I will elaborate on that. But the fact is the Revolutionary War was the first explosion of this stable social order. Following the revolution, the order reasserted itself, but in complicated ways. The second explosion, disruption of stable order in the United States, was the Civil War. The impact of the Civil War on American society was enormous. It really, you can't overstate it. For at least two reasons. First of all, the numbers of deaths. In the Civil War, more people died than all of the other wars that the United States has been involved in to this day. I mean, including the Iraq War, including Vietnam, World War II, all of these things. The other disrupting element was that people were having trouble understanding what the war was about, but it kept escalating and escalating in the numbers of deaths. And in the South in particular, the impact was really stunning. The male population between 18 and 30 in the southern states, 1/4 of them died during the 5 years of the Civil War. If you translate the actual deaths in the Civil War into the deaths that we lost in the Second World War, you would have not 50,000 deaths, or I'm sorry, 400,000 deaths, you would have 7 million deaths. So this was stunning. And for a long time, the Civil War had its grip on American society. The third period of disruption of the existing social order was in a sense more gradual, but ultimately quite as complete. It started with the Great Depression in 1929. The Second World War added to it, but then came the explosion of the 1960s, the protests, the Vietnam War, the assassination of President Kennedy, of Martin Luther King, of his brother. And again, speaking as someone who lived through those assassinations, it's really hard to overstate the way that the assassinations themselves undid our assumption that there would be social order, that we lived in a caring society, in a society that would take care of us. The symbolic value of the president was simply enormous, and in a way we didn't realize it until he was killed. And then his brother was killed on the way to replacing him in the presidency. And then Martin Luther King was killed. So these are the three episodes. And again, I'm painting quickly and with a broad brush. The thing that's particularly interesting and that I want to focus on today and tomorrow is the periods immediately following these three explosions, the Revolutionary War, the Civil War, and what culminated in the 1960s. Because the thing that's quite fascinating that happened is that after each period, there was an emancipatory interval, a time of emancipation of the formerly oppressed people. And it's quite striking that should be. So after the Revolutionary War, the emancipatory interval looked, again, speaking quickly, roughly like this. As I've told you, the colonists conceived themselves as slaves, but they also understood that there was something wrong with calling themselves slaves and throwing off slavery at the same time that they held slaves. Samuel Johnson the British commentator and dictionary originator, captured it very well. He said, "We hear the loudest yelps for liberty from the oppressors of the slaves." And as I say, that wasn't lost on the colonists themselves. Oh, I'm too close to the microphone. Is this better? Can you hear me now? Now, can you hear me now? Yeah. I have like 1/8 of an inch of tolerance here, but if I move too close, then I can hear it actually. So, but if you can't hear me, particularly in the back, raise your hand. So the colonists thought of themselves as slaves, and after the success of the Revolutionary War and the recreation of a governmental structure, for about a 30-year period, there was significant improvement, significant moderating of the enslavement of blacks on the one hand. The improvement came about the passage of emancipation statutes in all of the northern states. Slavery had been legal everywhere in the United States before the Revolutionary War. By 30 years afterward, all of the northern states had freed all slaves. At the same time, in the southern states, particularly the upper South, it became much easier to what they called manumit your slaves. That is to say, release them from bondage, either permit them to buy their own freedom, or simply the masters, particularly when they died, would specify in their wills that their slaves should be freed. And the consequence was a great expansion of the free black population in the southern states. So no slaves in the northern states, expansion of the free population in the southern states. The other important item of emancipation was regarding the Native Americans. Some of you may not recognize that. That's the accepted way to refer to the so-called Indian population in the United States. Before the Revolutionary War, there was essentially warfare between the colonists and the Indians, the Native Americans. After the Civil War, there was a new attitude, a new dominant attitude toward Native Americans, and that was, instead of fighting with them, rather than waging warfare, they looked for treaties, and treaties that on their face were very fair to the Native Americans. And at the same time, the goal of social policy toward Native Americans, immediately following the Revolutionary War, changed. The goal had always been, before that, to drive them away from, quote, white civilization. The goal after the Revolutionary War was to assimilate the Indians into the life of the white population. Now, again, there are oppressive and intrusive aspects to that, but still, it's very different from what went before the Revolutionary War and what started again 30 years later. And that was, we're not interested in assimilating Indians, Native Americans. We're interested in killing them. And in fact, we succeeded at that. We virtually decimated their population. The beginning of the 19th century, there were over 1 million Indians in the country. At the end of the 19th century, that number had shrunk to about 200,000. And they were either directly killed or died from disease. So it's a terrible history in the United States. But the important point that I want to make is that this was a moment of emancipation, an emancipatory interval that lasted for about 30 years. The emancipatory interval ended definitively with the election of Andrew Jackson to the presidency in 1828. Jackson was the first president who was not one of the founding fathers. All of the presidents before that, starting with George Washington, were part of the same small group. James Madison, James Monroe, the two Adams, who were not wealthy people like the others were all Virginia slaveholders. There was also John Adams and his son, John Quincy. But, you know, this is, of course, we're going back to that in a way in the United States with the succession of Bushes and who's the other? Clintons, yes, we're up to Hillary. In any event, that's an aside. Ignore that, a political aside. So when Jackson became president, he had made his reputation in killing Indians, actually, defending the United States against British invasion to some extent, but mostly killing Indians. And he was not one of the founding fathers. He wasn't part of the emancipatory impulse. And suddenly, the slave population was restricted again. The free slaves were evicted from the southern states, or else they were re-enslaved. And the Native Americans, again, were the subject of exterminatory warfare. That lasted until the Civil War. And then after the Civil War, again, there was what I call an emancipatory impulse. The emancipatory impulse you can see on the face of the United States Constitution. That is to say, the passage of the three constitutional amendments, the 14th, the 13th, 14th, and 15th. The 13th that's freed all the slaves. The 14th that guaranteed equal protection of the laws to all people, most notably including slaves and other former slaves, to reverse the meaning of the Supreme Court's opinion in Dred Scott, and the 15th Amendment to give voting rights to black males. So it was not a complete emancipation. In particular, they did nothing regarding the status of women, which was the subject of enormous bitterness at the time on the part of women's advocates. But in any event, it was what I would call an emancipatory interval. That lasted for exactly 11 years after the end of the Civil War. And what came afterward, in 1876 and onward, was a more aggressively repressive regime than we had ever experienced. The aggression against women, for example, tightened enormously. Most notably with regard to availability of abortion. Before the Civil War, abortion was freely available before quickening, which was considered the end of the first term, basically, and was not regulated in any significant way by any state. It was basically free abortion. After the Civil War, the doctors took over abortion and restricted it enormously and only admitted women to have abortion if their lives were threatened, or in some states their health. But again, the screws were tightened. On the black population, the screws were tightened in some ways even worse than the time of slavery. This was the time when the Jim Crow regime was invented, of racial segregation. Blacks and whites were not permitted by law to associate in any public facility, public schools, transportation, movie theaters, hotels, anything. And the degradation that worked on blacks was purposeful and enormous. In addition, blacks were worse off in this way than they were under slavery. Under slavery, white owners had very strong interests in maintaining the life and health of their slaves. So they protected their slaves, their black slaves, from aggression by other white men. After the Civil War and the passage of the 13th Amendment, the economic stake that white men had in black slaves' lives was gone. So this was a regime of lynching, of the Ku Klux Klan rioting, of random killings of blacks, in part to enforce the social etiquette of racial segregation. In addition, there are so many ways. I'll mention one other restrictive regime that originated after the Civil War and reversed this emancipatory interval, and that was the treatment of same-sex sexual relations. Before the Civil War, same-sex sexual relations had been frowned upon, significantly frowned upon, but they were not criminal. They were not criminalized under state statutes. After the Civil War, the screws were tightened. What happened after the Civil War was the invention of a new category of human beings. Before the Civil War, people could engage in same-sex relations, men with men, women with women. It was not approved of. It was religiously condemned in many ways, but it said nothing about the essential character of those people. There were people who made mistakes in their sexual preferences. After the Civil War, if you engaged in same-sex relations if two men engaged in same-sex relations, they both were a new invented term, which is homosexuals. The idea of a person who was a homosexual did not exist before the end of the Civil War in the country. So women's abortions were restricted. Homosexuals were regarded as a different order of humanity. Blacks were segregated against through Jim Crow arrangements. They were pushed out of voting capabilities in violation of the 15th Amendment. And in addition, the new competition, warfare, I would say, between capitalists and laborers, because of the transformation of the economy of the United States, became a very dominant experience in the country. And this lasted, all of these repressions lasted virtually untouched until the Great Depression and the beginning of the unraveling. Now, when this third era that I've identified came, the era of an explosion of instability, up to and most notably the 1970s, once again, this explosion was followed by an emancipatory time. Groups that had been oppressed but silent suddenly, kind of in order, protested, threw away their silence. And what we have done in the last 50 years in the United States is moved from group to group with emancipatory agendas, starting with blacks and the end of racial segregation, culminating, I would say, in the election of Barack Obama as president, our first black president. But before that, in many, many ways, being emancipated from their former status. We're not in heaven. We're not where the lion lies down with the lamb. But again, I can tell you as someone who's lived through this, it's a very different attitude between whites and blacks than before this explosion, I'll call it, of the 1970s. Then women. The second feminist movement erupted in 1965 with the publication of Betty Friedan's book. And suddenly it became a very powerful force in the United States. And in part they borrowed the vocabulary of the black emancipatory movements and the cost to them of public protest. But that was not understood, either by the whites in the South and certainly not by the whites in the North. And I'll develop that later. But the important thing is that these groups began to speak for themselves. They were provoked by the Supreme Court, and basically, in my view, it's because they felt that the courts were giving them a hearing for the first time, that they had an audience that they had never had before, so that when they protested, they would expect some kind of response. Again, to demonstrate that, Martin Luther King gave his first speech as the leader, or the speech that made him the leader of the American Civil Rights Movement in 1955 in Birmingham around the bus boycott started by Rosa Parks. Before this speech, he was unknown. After the speech, he was the leader. And in that speech, he said, "We are not wrong in opposing segregation. We are not wrong. If we are wrong, then the Constitution of the United States is wrong. Then the United States Supreme Court is wrong. Then God Almighty is wrong." Now, there's something quite stunning and stirring about his association of the Constitution, the Supreme Court, and God. You can talk to some Supreme Court members and they wouldn't be surprised by it. But those of us who are a little more critical kind of worry about that. But it speaks to the central role that the Supreme Court played for Martin Luther King in the eruption of the black civil rights movement. So that's my speculation, that it was the activity of courts that were the crucial difference, and continue to make the difference, even though it's a little more complex now. The court is not uniformly and unanimously behind emancipatory movements and are cutting back in a variety of ways. But the core of the emancipatory movements remain still alive, not intact completely, but still alive, still powerful. So what is it that supports my speculation that the courts played the crucial role following the 1960s? Well, I want to stop here, not end, but give you a personal testimony about, in my own life, the impact of Brown v. Board of Education. And I will end after giving you that personal testimony and also trying to master this technology here of putting a few pictures up on the screen. In tomorrow's lecture, what I will try to do is to give a more extensive theoretical picture that I'm telling you in advance is drawn from my own experience. My own experience with Brown v. Board of Education. Brown, as I say, was decided in 1954. I have already hinted at my great age. I will now reveal it precisely. In 1954, I was in the 10th grade in suburban Maryland, Montgomery County, Maryland. Suburban Maryland was below the Mason-Dixon line, but those of us, those white people at least who lived there, considered Montgomery County to be a kind of a northern outpost. Liberals, intellectuals, we were good people, and we affiliated not with Southern bad supporters of race segregation, but instead we were really a part of the North. Well, Brown v. Board of Education woke me up, but I want to speak to some of the awakenings that I went through immediately before Brown and then after Brown and the consequences in my life, to then speculate about the power that the court has as it was exerted on me and many other people like me. So I have three pictures that I want to share with you, if I can get this to work right.
She's coming to help you.
Oh, there we go. Yeah, this was not what I was taught for. All right. So that's the first picture. Now, the small type is hard to read. I'll interpret it for you. This was a sign that was outside a beach club in Maryland on the so-called Eastern Shore. I lived in the western part of Maryland. The Eastern Shore of Maryland was a part that we regarded as rednecks, as really a part of the South. Maryland was split in two, and the Eastern Shore was the bad Maryland. It was also our only access to water. The Chesapeake Bay was on the Eastern Shore. And in 1953, actually, when I had graduated from 9th grade, junior high school, I worked as a waiter in a sleepaway camp run by the Jewish Community Center of Washington on the Chesapeake Bay. Every week we had a free day. Now, I was too young to drive. I didn't have a driver's license, but I made friends with some of the counselors, and they had old cars and driver's licenses, so we would go out together. Beverly Beach was about 15 minutes from our campsite, and I discovered it the first time that we took a trip, a road trip, away from the camp, and was kind of stunned. And then a little of me was amused, which is strange, but at finding this public sign. Now, you see what the sign says. On the very top it says no dogs. Then in the middle it says Gentiles only. Well, of course that means no Jews. That meant me. That meant the driver of the car. That meant all of us at the Jewish Community Center camp on the Chesapeake Bay. And then the small type that you have trouble reading, and I'll translate it for you. The small type said, Gentiles only of Northern European ancestry. So it's a qualification. What it means, what it obviously was meant to mean, was no blacks. Blacks, by and large, were Gentiles, non-Jews, but they didn't have Northern European ancestry. It's possible that it also meant no Catholics or no Polish and Italian Catholics. I don't know that. Now, I should say, too, about this sign, when we encountered this sign, we debated amongst ourselves, I mean, how do they know we're Jewish? You know, I mean, Well, there was only one reliable way, and even that way was not a universal rule. So we joked about it and said, should we try and pass? Well, no, we didn't need to pass. But this was the first confrontation with open anti-Semitism that I had in the United States. This was not the first time for open anti-Semitism in the United States. Previous generations previous Jews lived under great restrictions. But when I look back on it, there were restrictions that I overlooked. When I graduated from law school, for example, all of the so-called, the prestigious firms, they were called the white shoe law firms in New York, in Washington, and Los Angeles, did not hire Jews. And there were long lists of firms in which we were told, don't bother to apply. You won't be hired. At the same time, there were quotas about the numbers of Jews permitted in institutions. When I went to college, I know, but nobody pushed my face in it, that there was a 10% quota. I went to one of the Ivy League schools, and throughout the Ivy League, the rule was, well, we accept some Jews because, after all, they score high in tests, but we want to make sure that we remain a Gentile institution, so we'll accept up to 10% of the entering class and no more. And in my entering class in Princeton, which is where I went, there were, mirabile dictu, 9.9% Jews. But again, we lived with it. We were silent, I guess one would say, with the oppression. And it was better than it had been in our father's generation, and even better than our grandfather's generation. So that was Beverly Beach. Beverly Beach reappeared in my life 2 years after Brown v. Board of Education was decided. I said I was going in when Brown was decided into the 10th grade, the senior high school. It's called Montgomery Blair Senior High School that I attended. So there was Brown. I was glad, I was a young liberal. It seemed like a nice, sensible opinion. But I had no idea that it had any impact at all on my life. In the 11th grade, in 1955, in my school, which was a school of 2,000 students, suddenly there were 20 black students. I was amazed. Where did they come from? I thought to myself. Well, two things turned out. One, these black students lived closer to my senior high school than I lived. They actually lived in a section of Montgomery County where there were no paved roads, there was no indoor plumbing, there was a population of, I think, around 100, maybe 150 people. The land that they lived on had been granted to their ancestors by Abraham Lincoln for freed slaves. And at the time that he granted that land, it was in Silver Spring, Maryland, miles and miles away from any, quote, civilization. But then the suburbs expanded, and we built around Montgomery Hollow. That's the name of the place. I kind of knew it existed, but really didn't know, and I had never seen it, even though it was directly behind my junior high school. Now, at this point, when I'm in the 11th grade now, this is 1955, I said, where did they come from? Who are they? And by then I had a driver's license, so I borrowed my parents' car and drove onto this dirt road and found myself transported into my image of the Deep South. The houses, there were maybe, 10, 12 houses. They were all wooden shacks. They had on their front porch refrigerators, washing machines. There was a couple of wells that you could see. This is where people got water. There were outhouses attached to or in the back of those houses. There was no indoor plumbing. And here they were, maybe 5 minutes drive from my junior high school. So that's where they came from. But then why weren't they in my class beforehand? I thought I lived in a liberal Montgomery County. Well, it turned out, unbeknownst to me up to this point, that the state of Maryland had passed a law permitting the local school boards to segregate their schools if they chose. And the Montgomery County School Board was actually among all of the other school boards in Maryland in running segregated schools. So the stunning thing was, and I want to underscore this, I was living in a segregated school system and I didn't know it. Now, you know, should I have known it? Well, I knew we were all white, but my assumption was we're all whites because the blacks can't afford to live in these neighborhoods. You know, they lived, lots and lots of blacks lived in the District of Columbia, but that was a different jurisdiction, and they were demonstrably much poorer than the rest of the people that I knew of and knew in Montgomery County. So suddenly, Brown has decided, the Montgomery County Board of Education, because they really held the same image of themselves that I did. We're a liberal, good people. They didn't resist the way the Deep South resisted. They immediately complied with the order in Brown, and that meant that black students were brought in to the school population immediately. Now here's the wrinkle. Now I'm in the 12th grade. There are 20 black students in the class of 2000. And in the 12th grade, I was elected to the student council of our firm. In fact, I tell you, because it's mostly amusing, I was Chief Justice of the school. That's the only judicial office I've ever held. And it was an elected position. Nobody called me Mr. Chief Justice, though, I'm sorry to say. In any event, I was on the student council. And one of the roles of the student council was to organize the graduating seniors' annual picnic. Every year, for as long as anybody could remember, the senior class gathered together, got on school buses, and went on a beach party where they all got drunk and celebrated their imminent graduation. And the beach party was where? Believe it or not, Beverly Beach. So on the Chesapeake Bay, those were the only beaches nearby, and we always dealt with Beverly Beach. Well, I remembered the sign. I wasn't alone in remembering this. If we, in 1956 now this was, if we had our beach party for the senior class in Beverly Beach, as we always did, the black students couldn't attend. The Jews couldn't attend either, and there were a very small group of Jews in my class. But as I say, you know, I think it's a little hard to tell a Jew from a Gentile, definitively, but not at all hard to tell a black person from a white person. So what do? Well, so this discussion in the student council, and the first position that was suggested was, why don't we send a delegation to meet with the 20 black students and say to them, look, we have this tradition. And everybody in the school loves the idea of the senior beach party. Now, it is true that the only beaches that we know of, and it's not just Beverly Beach, all the public beaches on Chesapeake Bay refuse to admit blacks. And so this group within the student council said, so we explain that to the black students, and we say, you certainly don't want to be responsible for depriving all of the white seniors, who hugely outnumber you, of their tradition of having a beach party, do you? So that was the first suggestion. Well, a number of us, and I'm proud to say that I was one of that number, said, you can't do that. That's just outrageous. It's insulting to the black students, and to put the burden on them of their presence in the school, hurting the white students, is just intolerable. So you can't do that. We only have one possibility, and that is cancel the beach party. Okay, because they have this, and I, by the way, parenthetically, I was the only Jew at the time on the student council. I said nothing about the Gentiles only sign. This is another part of silence that I'll develop a little bit. But I was all for the rights of blacks, and sincerely for the rights of blacks. And so we canceled the beach party. But then we had a further discussion. It was really a wonderful moment in my life, as young as I was. The further discussion was, we can't let anybody outside of this room know the reason that we're canceling the senior beach party, because we don't want to target the black students. And if we tell in the senior class generally, we're not going because they don't admit blacks, it's a prelude to targeting of the black students. So we all swore to secrecy. And we made up a story The story was that the Beverly Beach Club and all the beach clubs in the Chesapeake Bay suddenly increased their rates enormously, and we couldn't afford it. And that was the reason, and we all agreed that would be the reason. But at the same time, and I marvel when I think back on this and how smart we were, we instructed our faculty advisor, who sat in on all of our meetings, that he should write to the Beverly Beach Club and tell them that we're not coming this year, and we won't come again until they get rid of their policy excluding black people. Parenthetically saying nothing about Jews, but that's okay. One policy goes with the other, or so I imagine. So Mr. Fox, our faculty advisor, sent that letter, and he never got an answer. But we didn't go to the beach. Now, I say, you know, this is Brown v. Board of Education. The thing that's stunning to me about the role that the court played in my life was, here I was living in a segregated school system and I didn't know it. Brown was decided and suddenly I knew it. And then I was given an opportunity to repair the damage. Now, you know, it was limited in its reparative effect, but to stand up on behalf of blacks being equal members of my community. This again followed from Brown v. Board of Education. I'm sure that the 9 justices who decided Brown didn't say, well, what will the students in Montgomery Senior High School think about this? But this was the impact, this bringing into public visibility, this telling people like me, you don't realize it, but you're part of the problem. And if you're not part of the solution, you are part of the problem. It kind of pulled the wool from my eyes. It opened my eyes. As the black spiritual puts it, I had been blind, but now I could see. And it's not just me. It's the entire student council. How to deal with this new presence of black students in a respectful way. And I think we acquitted ourselves. But the point is, the court created the forum for that, gave us the challenge and the opportunity to do that. Now, going public had another impact that the court had. And that's the last 2 pictures that I want to show you. This was a picture taken in Little Rock, Arkansas in 1957, when Orville Faubus, the governor of Arkansas, called out the troops, the state National Guard, to block any black student from entering any formerly segregated all-white class. In particular, this was outside the Little Rock Senior High School. There were 9 black students who were brave enough to say, we will be the vanguard. We will together break segregation in the Little Rock schoolhouse. The governor called out the troops, and then President Eisenhower, surprisingly, nationalized the state troops and called out the United States militia to escort those black children into the schools. But they were surrounded by mobs of protesting whites. And this picture, and then the same woman with her mouth open, hurling imprecations at these black students with great dignity who were going into the school, became known throughout the United States. The press was down in Little Rock because the issue was so alive, and they were there taking pictures. And what they saw in these 2 pictures that I took of this woman wearing, you can't quite see it, a crinoline skirt. She was, one might say in ordinary times, the epitome of Southern womanhood. You know, sweet women, docile women, polite women. They were Southern belles, after all. But here's what protecting race segregation did to those women. And you can see in her face and in these 2 pictures the hatred and the violence that was just beneath the surface in the Jim Crow regime, in school segregation. It brought out the true meaning of segregation in their lives. the extent to which segregation was supported by violence and hatred, their Negroes were not happy. They were not happy. They were filled with rage, and their rage was dampened down, and the Supreme Court said, you can't do that anymore, and the rage erupted. And we all learned things. I mean, you know, I learned that I had been living in a segregated school system. The whole country learned that the South was not what we thought it was, that it was a place filled with violence and hatred, and that it was something that had to be changed and cured. So it was the beginning of the kind of reception of an emancipatory impulse, not just in the courts, but throughout the country. This is an intolerable way to live, we suddenly realized. So the court was in the vanguard. Did the court accomplish this? No. The court set the stage for this. It set the stage for my knowledge. It set the stage for the knowledge of what was at stake in race segregation for the entire country. Now, in tomorrow's lecture, I want to go further, give you a more extensive account of judicial behavior, give it a theoretical account in a way that has not been done, in my view, in the literature about the role of the Supreme Court. But I want to take from this personal experience, and I hope those of you who come, and I hope to see lots of you tomorrow, will bear in mind, we're not talking about abstractions here. We're not talking about equality principles that exist in some kind of abstract world. We're talking about ideas of equality that directly impact the lives of millions of people in the United States and the response that they had. The stakes are very high, but the courts played a great role. And the point of tomorrow's lecture will be to identify good ways that they can play that role and not so good ways. And the court itself doesn't understand this. The court doesn't really understand what it did in Brown v. Board of Education, and it doesn't understand what it's been doing for the last 10 years for the rights of gay people. But I hope to give you an understanding and an account of what the courts are doing and an implicit jurisprudence that is on its way toward becoming explicit. I guess one could say, and I'll end here, that I was silent in so many aspects of my private life that in my public life as a law professor, I vow to be silent about nothing, even though I'm a minority of one. But we'll see tomorrow. Thank you for your attention, and some people might want to raise some questions now about what I've lectured so far. So I'd be glad to hear the questions and respond.
Sí, tal vez mientras se atreven o van juntando con esta, o van juntando las preguntas, yo puedo subrayar un par de cosas y decir algo más de lo que dijo, siguiendo el hilo de lo de Roberto.
I can today if you want to ask. I should say something.
Wait a minute. El par de profesores que se armó alrededor de Carlos Nino, el par de profesores de Yale que conforman Owen y Bo, Owen Fis y Bo Burt, tienen en común que tanto en el caso de Fis como en el caso de Burt, ambos tienen algunas ideas respecto de hacia dónde debería ir el derecho en Estados Unidos. Y respecto de esas ideas ellos están solos, digamos. Todo el resto de los profesores de derecho en Estados Unidos creen que están equivocados, básicamente. En el caso de Owen, su visión respecto de la libertad de expresión, y en el caso de Burt, como vimos hoy, vamos a ver mañana, el particular rol que él cree que tuvieron en su mejor momento, que tienen en su mejor momento los tribunales norteamericanos, y que deben tener si quieren ayudar en la expansión de la agenda constitucional, de la mejor agenda constitucional norteamericana. Lo raro, para traerlo un poco hacia nosotros, es que la idea de Owen Fee se convirtió en la ley de medios de comunicación audiovisual de la Argentina, o por lo menos sus argumentos respecto de la libertad de expresión fueron discutidos en el Congreso, en las calles y en los tribunales argentinos. Y yo creo que la teoría del derecho implícita, o la teoría del rol de los tribunales, de la jurisdicción tal vez, la teoría de la jurisdicción que tiene Burt respecto de los tribunales norteamericanos, que básicamente se centra en Brown versus Burt, pero no termina en Brown, también explica, o puede explicar, creo yo, la mejor jurisprudencia de la actual Corte Suprema Argentina. No lo saben los jueces estadounidenses, tampoco lo saben los jueces argentinos. El rol de Burt y de cualquier profesor de derecho es hacerlo explícito y tratar de, haciendo teoría sobre la mejor práctica, hacerla más clara y mejor. Pero yo quería subrayar ese hecho. Ideas que en Estados Unidos o que en otras jurisdicciones son marginales, viajan bien a veces a otros países. Y el impacto de esas ideas tal vez no sea tan grande, o por ahora, o no haya sido tan grande en su lugar de origen, pero tiene insospechadas connotaciones y efectos en otros países. Déjenme simplemente no adelantar, pero tomar un par de cosas de las que dijo Bo hoy y que voy a continuar aclarando mañana, y que son las siguientes. Él cree que los tribunales pueden trabajar en dos modos, en dos tipos de función. Hay jueces, hay políticos que él en un libro llama optimistas, gente que cree que los conflictos se pueden resolver. Y gente que él llama, tal vez irónicamente, pesimistas, que solo creen que los conflictos se pueden administrar. Y Burt siempre ha sido un pesimista, como muchos de nosotros, porque sabe del peligro del optimismo, del peligro de estar rodeado de gente que sabe, que cree que el conflicto se puede terminar de una manera, de una vez y para siempre. Casualmente esa gente cree que la forma de terminar los conflictos es la que ellos creen que es la correcta. Por lo tanto, los optimistas son optimistas solo cuando ellos pueden dar la última palabra. Y lo que empezó a contar hoy Burt, y va a terminar de contar mañana, es el daño que los optimistas le hacen a la política y al derecho. Y en qué medida los pesimistas, con una visión tal vez un poco más optimista respecto de las capacidades de la deliberación pública y de la fraternidad, si bien no creen que el conflicto se pueda resolver, creen que el conflicto se puede administrar, de forma tal que tal vez el conflicto sea una forma de encontrarse y no de separarse. Esa es la promesa de Burt para mañana. Yo, mientras, le quería preguntar una cosa. Hay una increíble historia que sigue a estas fotos entre la mujer negra y la mujer blanca que grita. Y le quería preguntar si nos puede contar esa historia.
Well, if I know the story that you're referring, I'll tell the story. It may not be the story that you have in mind.
I'll tell mine, you tell yours.
Yeah. But this very woman whom you saw shrieking on the pictures was interviewed by the New York Times about 2 or 3 years ago. And it was startling to read this opinion. She obviously was older, but still kicking. And she said, she acknowledged that she had become the symbol of hatred and violence in the whole Jim Crow era. And she further said that when she looks again at those pictures, she doesn't recognize herself. She said, that's not me. You know, I'm not a person who shouts insults at young black children, but I know I did. I mean, there it was. And I'm ashamed of myself, actually. And I hope to be redeemed. I am not that person. Well, of course, she was that person, but she recanted and relented. And that also, as I'll develop tomorrow, is the kind of stock in trade of the Supreme Court of the United States, to present sites of penitence, one might say. So this very woman is a wonderful illustration of that. And I think that the entire South came to feel ashamed of itself, but not right away. Their first impulse was to resist. That's so-called massive resistance, and to shriek and to have their violence revealed, and to have George Wallace, the governor of Alabama, stand in the front door of the courthouse saying, segregation today, segregation tomorrow, segregation forever. So there was a wonderful process that took on, and this woman illustrates that. I have to go into the archives for the book that I'm now working on to find that New York Times article, but it will appear. Is that what you had in mind?
It was, but I think I recall that they said that they met the black woman and the white woman.
Oh, that's true.
And they went on tour,
that's right,
giving talks together about that experience.
That's right. So those two women reconciled in a way that the whole country, in many ways, not in total ways, reconcile. And that brings me to my optimistic view.
Yeah.
I mean, Martine calls me I'm not a total pessimist. We have a black president. We may disagree with him. You know, we may be disappointed. I am disappointed a lot in what he's doing. I don't care. To me, it is amazing that being a black man in the United States in 1955 meant that you were the lowest of the low. It was like homosexuals. It was a characterization of what it meant to be black. And now we have the decency to distinguish among blacks, at least. So some blacks the white people don't like. But some blacks get elected President of the United States and Attorney General and Secretary of State. Unheard of 50 years ago. And that ultimately is a tribute, I think, to Brown v. Board of Education and the U.S. Supreme Court. Not acting alone, but getting these things started. So, thank you, Martine.
Yeah, you're welcome. Tengo Laura y atrás.
Por supuesto, no podía dejar de traer la parte tal vez más oscura de la historia contada, que es una pregunta referida al fracaso, desde mi punto de vista, de esta historia emancipadora que en algún momento tuvo ese impulso emancipador tan fuerte. Estoy pensando en las cárceles llenas de personas de origen, ¿no?, de afroamericanos. Estoy pensando en las mismas cárceles donde las personas trans o homosexuales son totalmente denostadas. Estoy pensando en la mayoría de los pobres negros. Entonces me gustaría saber dónde es que ese impulso emancipador falló. ¿Qué fue lo que pasó? ¿Dónde es que se quebró ese impulso emancipador?
Well, first of all, Laura, I would say you're one of the people I was referring to as having such perfect English that I just didn't need to learn any Spanish. So I'm amazed that you would, but still it's easier for you, and that's fine. You are younger than me. Identifying prisoners, for example, the emancipatory agenda is still open. There are many, many slots, and I hope I get in tomorrow's lecture to the role that I see for prisoners' rights in particular. But the groundwork has been laid. The sensitivity has been laid. And what I read you as symptomatic of is looking at our society and saying, yes, but where is it not emancipated? It's emancipated here, it's emancipated here. That question until the 1950s was not being asked. We were a land of freedom and liberty. We were proud of ourselves. Everything was perfect. Oh, well, maybe there was a little protest now and again, and maybe all blacks in the South weren't treated in wonderful ways. But basically, everybody was happy with their status. That is not true anymore. It's not plausible anymore. And on the court's agenda, there has to be, and there will be. And I think prisoners' rights in particular. Last week, there was a decision by a federal district court in New York ruling that solitary confinement for prisoners violated the United States Constitution. It was cruel and unusual punishment in terms of the damage that it had done. Now that ruling is not going to be appealed because the new mayor of New York, Bill de Blasio, endorses that idea. So you will dramatically restrict, hopefully even eliminate, and they're talking about it, solitary confinement. And this is part of a trend that's going to gather force. But you're absolutely right, we are far from achieving consistency with our ideals, but we are in a position in which we can do what you have done, which is to say, yes, but you still haven't addressed this problem, and there's this problem, and there's this problem. There are still people who say, no, that's not true, you're a rabble-rouser, what shall I call it, the John Roberts, Antonin Scalia, Samuel Alito branch of the Supreme Court. But they're still outnumbered. And I hope they will continue to be so. And in any event, they won't continue to be so unless all of us keep fussing like we are.
Quizás, ¿se escucha? Quizás esté entrando en el tema de la lectura de mañana y en tal caso me disculpo. Quizás esté entrando en un tema de la lectura de mañana y en tal caso me disculpo, pero usted sugiere que el cambio en el rol de los tribunales, de la Corte en particular, es el rasgo distintivo de este tercer periodo. Yo quería saber si usted tiene alguna opinión de a qué obedece este cambio en sí mismo. Si obedece a incentivos institucionales o al impulso específico de ciertas personas en particular.
Yeah. That's a very interesting question, and I have no answer for it. I mean, all that I know is that for a time, all of the members of the Supreme Court had a dramatically different view of their function. You can date it to a particular decision of theirs that some of you may know in 1939 in the Caroline Products case. Caroline Products was a nothing case on its face. The United States government was regulating the amount of whole milk that you had to have in a product that was called a milk product. So it was an easy case. And they affirmed the government, but they had a footnote in that opinion, which was the most famous opinion, you're nodding your head, in Supreme Court jurisprudence, footnote 4, in which they said there are certain kinds of legislation, and in particular, legislation that works to the disadvantage of discrete and insular minorities who are not likely, against whom prejudice by the majority is likely to be strong. And in those cases, there is a special role for judicial scrutiny, which is not true for the economic struggle, which had been the previous court's feat. Now, where did that come from? Well, the history that I have read of footnote 4, it was in an opinion by Chief Justice Harlan Fiske Stone, was that he was talking about minorities in Europe, not about minorities in the United States. It's just weird, but all he knew was that there was something important in the judicial role to protect discrete and insular minorities. Now, should they be discrete? Should they be insular? If you take that language seriously, then the court would never attend to the rights of women, because women are not a discrete and insular minority. They're actually a majority. They are discrete, but they're not insular. The formula doesn't work, but the impulse is there to look for oppression in our society. Where did it come from? Well, I honestly don't know. All I can say is it's there, embrace it, build on it, don't reject it. So there's still a dispute on the Supreme Court, as I say, with the Roberts-Scalia Thomas. I forgot Thomas. And Alito Branch. I'll think some more about by tomorrow. But I didn't have in mind to address the question, so I'll think about it tonight.
Hi, I'll speak in English. My question is the following. You mentioned 3 events that basically had a major impact on redefining the code.
Straight to your mouth. No.
Más cerca. But the one that you didn't mention, and we live in the States, is 9/11, which, as far as my experience, has changed the nature of the country, coupled with changes in technology, has impacted my freedom, my privacy. Where does that fit in your?
Yes. Well, I didn't mention 9/11. No. I think it's unclear what the drama of the impact that it will have. There are a lot of things of concern. There are the targeting of the Muslim minority in this country and blaming all Muslims for what happened in 9/11. On the other hand, it's pretty well accepted that 9/11 was the work of Osama bin Laden and his immediate group, and he's now been captured and killed and all of that. The other aspect that you speak to, though, are the use of new technology to invade our privacy. But that's coming before courts. Courts are kind of suddenly alert to that. So the debate is not over. Is 9/11 with the same significance as the Revolutionary War, or the Civil War, or from the Great Depression into the 1970s and Vietnam protests and the whole country falling apart and presidents dying? Well, some people would say it changed everything, as you have said. Again, I keep dragging in my being so old, but maybe I've seen a lot of these things, and then people say, oh my God, here's another thing. And I'm saying, well, I don't know, it may not be so big. But the important point is, I think that people like you are alert to the significance of this and the way that it undermines important principles that we have. And you can see courts waking up to this too. So you may be right, and it may be that somebody who comes to Palermo Law School in 2035 and looks back will say, well, there were 4 periods, and there's the post 9/11 period, and I'm living in it and I don't know it.
Creo que comparto bastante de su visión sobre el rol de los tribunales y que mañana vamos a hablar más sobre conceptos. Quiero referirme a una cuestión histórica en el relato que hacía hoy. Yo tengo la impresión de que la Corte Suprema de los Estados Unidos en los últimos 30 años ha empezado a desandar el trabajo emancipatorio de los años anteriores. Esta visión minoritaria que decía Martín en temas como libertad de expresión de Buenfils o los suyos son minoritarias respecto de lo que la Corte viene decidiendo. Entonces, quería saber si podía elaborar un poco más sobre la Corte Suprema, no la actual, sino de los últimos años, y de la actual, no sé, mi pobre interpretación de la jurisprudencia norteamericana, que digamos es como un extraño al derecho norteamericano, pero la decisión, por ejemplo, que la Corte toma cuando de algún modo sostiene la constitucionalidad del sistema de salud de Obama, algunos ven en esa decisión un germen de desarmado de una interpretación de la Constitución que de alguna manera justifica incluso la ley de derechos civiles. Y el caso Bush versus Gore también es otro caso que en el relato... Recuerdo un profesor de Derecho Constitucional en Yale, no voy a decir el nombre, que luego de esa decisión dijo, no voy a poder enseñar Derecho Constitucional nunca más después de esta decisión, porque ya no hay más Derecho Constitucional en los Estados Unidos. Entonces, quería saber cómo veía algo hay en el paper, pero me gustaría que desarrolle ahora.
Well, I've painted with a broad brush, but honestly, Roberto, I think you have also painted with a broad brush. In this extensive, what I've called emancipatory interval, there has been conflict. There are some people who want to reassert the kind of the old or a new version of the old order, and there are some who do not. But I think that it's wrong to say that the Supreme Court has undone, in truly powerful ways, the achievements of their emancipatory interventions. Now, tomorrow I'll say some critical things about Roe v. Wade, about its process, but the fact is Roe v. Wade is still the law of the land. There are 4 votes to overrule Roe v. Wade, but it's still the law of the land. The emancipatory agenda for LGBT people, for gays, is very much alive in the court. And I think we're just at the edge of the court embracing as a constitutional principle the right to same-sex marriage. Maybe that will happen, maybe it won't, but the court has been instrumental in moving that forward. With regard to disabled people, what has happened in the whole emancipatory agenda, the crucial act is the Americans with Disabilities Act of 1991. And what that speaks to, and it equally speaks to what the court has done in the Voting Rights Act, the Congress now itself has awakened. The court is not alone. So the disability rights agenda has been carried forward by the legislature. The courts have been cooperative, and in fact they've interpreted the Americans with Disability Act in very generous ways to continue this emancipatory agenda. The most recent voting rights cases in which the court ruled unconstitutional the heart of the Voting Rights Act, what the court did in ruling that unconstitutional was to overturn an act that had been enacted by a virtually unanimous Congress in both the Senate and the House. So we haven't heard the end of that dispute. And I think there's general malaise in America and rigidity in our public institutions. But if there's going to be any legislative action in the next 3 or 4 years, I predict that it's going to be on voting rights. So these are matters that are still in struggle, but they are very much in play. A word about Bush v. Gore. I am one of the, this is not me who you quoted, I'm one of the teachers at Yale Law School who teaches constitutional law. Bush v. Gore is the best thing you could say about it. It's a disgraceful decision. It's an unprincipled, it's an outrageous decision. When you read the decision on its face, it admits how outrageous it is by saying this has no precedential value. Yes. What is that all about? It's really, but it's a revealing bad misstep by the United States Supreme Court. Now it turns out, as subsequent research has shown, that Bush would have won the presidency anyway. So he didn't need Bush v. Gore. So at the time I was more outraged. I was outraged about so many things, but I was most of all outraged that they stole the presidency from Al Gore. I now feel that Gore lost the presidency all by himself. I mean, it's such a comedy of errors. The crucial votes in Florida, you get me started on this and I have to stop, but the crucial votes in Florida were cast by 3,000 Jews, mostly Holocaust survivors, who voted for the most openly anti-Semitic person on the ballot because they were using what was called the butterfly ballot, and you look at it and you get very confused. They thought they were voting for Gore. They, in fact, these 3,000 people all voted for Pat Buchanan. They didn't mean to vote for Pat Buchanan. They were horrified. With those 3,000 votes in the right column, Gore would have won the presidency. But that wasn't the Supreme Court's fault. That was the people who were designing the ballots. In any event, bottom line, Bush v. Gore is horrible. But it fits outside a lot of the other jurisprudence of the court. It's a complicated picture. And you're right to call attention to the negative sides of this, but I insist that there are also positive sides to this, and particularly if the Supreme Court knew what it was doing and what it was about. And that's one of the things that I want to offer my voice to them and to you and to my wife and everybody. Right. My wife says so much for being a pessimist. I think I'm a realist, but it gives me more of an optimism. I think you're Argentinian, Martín. It's the problem.
Muchas gracias y los esperamos a todos mañana.